Today, let's unpack this. We usually spend our time here talking about, optimizing your life, new tech productivity hacks. But today we are wading into some heavier waters. We're talking about the one scenario that absolutely nobody puts on their calendar.
Mm.
You plan for quarterly reviews, you plan for tax season, you might even plan for a server crash.
Uh,
But nobody plans for that phone call, the one that says a member of your team has passed away.
it's the ultimate disruption. And honestly, it's emotional, obviously. It's a tragedy, but it also triggers this legal and financial domino effect that
Yeah.
most people are just completely unprepared for.
That is exactly why we're doing this. We're looking at a source document today titled Prestaciones Familiares tras Fallecimiento Laboral, which translates to family benefits after a labor-related death. And the mission for this deep dive is to look past the tragedy for just a moment and focus on the mechanics. When a worker in Mexico dies, what happens to the money? What rights does the family actually have? Because I imagine there's a lot of confusion between, what would be nice to do and what the law says you must do.
Precisely. And to be clear, we aren't just talking about company culture or charity. We are talking about hard, codified rights under the federal labor law, the LFT. Ignorance here is incredibly expensive. If you're a family member, you could leave life-changing money on the table. If you're an employer, you could face lawsuits that, frankly, could bankrupt you.
So let's establish the baseline. The source material makes a very specific distinction right at the start. It separates the money into two buckets.
Mm-hmm.
Bucket number one is cash the worker had already earned but hadn't collected. And bucket number two is cash that is triggered specifically because they died.
Right. Think of it as the past versus the future.
Uh,
The first bucket is protection for work that's already done. The law, specifically the spirit of the legislation, is trying to ensure that the economic engine of a family doesn't just, shut off overnight. The dependents have rights to the fruit of that labor.
Okay, let's tackle the past first. The document refers to this as the finiquito. Now, we hear this word a lot in Mexico, usually when someone quits or gets fired.
Right.
But here, it means the settlement of accrued benefits.
Correct. The finiquito covers prestaciones devengadas. That legal term, devengadas, just means accrued. It's money that was already legally theirs. It just hadn't hit their bank account yet at the moment of death.
The most obvious piece here would be the unpaid wages. That seems simple enough.
It is. If I pass away on the 14th of the month and payday isn't until the 15th, those 14 days of salary aren't a savings for the company. They are a debt to my estate.
Because the days were worked.
The days were worked. They must be paid.
Okay, straightforward. But then we hit the aguinaldo, the Christmas bonus. This is huge in Mexico. Article 87 of the LFT guarantees 15 days of salary per year. But the common logic is, it's a Christmas bonus. If I don't make it to December, do I lose it?
You do not. And this is a very, very common misconception. People think the aguinaldo is an event-based bonus. Legally, it's not. It accrues day by day. Every single day you work, you earn a tiny fraction of that Christmas bonus.
So it's prorated.
Exactly. The source uses 2026 as our reference year. Let's say a worker passes away on July 1st, 2026. That's exactly halfway through the year.
Right.
The family is entitled to exactly half of that year's aguinaldo.
Hmm.
It's a mathematical calculation, not a discretionary gift.
That makes perfect sense. It's money earned, just deferred. Does that same prorated logic apply to vacation time?
It does, but with an extra layer that people often miss. First, you have to look at the previous year,
The previous year, why?
because people save vacation days. If the worker had 10 vacation days from 2025 that they were saving for a rainy day and never took, those must be paid out in cash. 100%.
Plus whatever they earned in the current year up to the date of death?
Right. But here's where you have to watch the math. You can't just pay the daily rate for those vacation days. You have to add the the vacation premium.
That's the 25% surcharge, isn't it?
Yes. Under the law, vacation days are always worth 1.25 times a normal day's salary. That premium is a non-negotiable right. So if you're the executor or the family member doing the math, don't just count the days. You have to add that 25% on top. It adds up.
Okay, so let's summarize bucket one, the finiquito. We have unpaid wages, we have the proportional aguinaldo, we have accrued vacation days from previous years and from the current year, and we have the vacation premium on top of all of that. That's the money that belonged to the worker already.
Correct. That money is payable regardless of how they died, when they died, or where they died.
Okay, now let's move to the second bucket. The money triggered by the death itself. And this is where the source material threw me a massive curveball. The seniority premium or the prima de antigüedad?
It's one of the biggest surprises in Mexican labor law for people who think they know the rules.
Because usually the rule is 15 years, right? I mean, I know people who stay at jobs they hate just to hit that 15-year mark.
That's the one.
If I want to quit my job and take my seniority premium, I have to have logged 15 years of service. If I quit at 14 years and 11 months, I get nothing.
That is the standard rule for voluntary resignation. It's a retention tool, a loyalty reward. But the law specifically, Article 162, Fraction V, it flips the script completely when it comes to death.
How so?
If the employment relationship ends because of death, the years of service requirement just vanishes. It is waived entirely.
Wait, so play that out. I get hired on a Monday. I work for 3 weeks. Tragically, I pass away. My family gets a seniority premium.
They do. The law views death as an involuntary termination.
No.
You didn't choose to leave. So the law mandates the premium be paid regardless of tenure.
Wow.
Doesn't matter if it was 20 years or 20 days.
That is a massive distinction. So how do we calculate it? Is it just my normal salary multiplied by the years?
No. And this is critical for employers to understand, or they will overpay. The formula is 12 days of salary for every year worked. But, and this is a big but, there's a tope, a cap.
A ceiling on the salary used for the math.
Right. This is laid out in Articles 485 and 486. The salary basis for this specific calculation cannot exceed twice the general minimum wage of the geographic area.
Let's put that in context, because minimum wage sounds small. But if I'm a senior manager making, say, 50,000 pesos a month, which is way above minimum wage, my family doesn't get 12 days of my 50K salary per year.
Correct. They get 12 days calculated at that double minimum wage cap. That's it.
Why the cap? It seems a little unfair to the high earner.
It's a balance. The law aims to ensure the family gets a meaningful lump sum, especially for long-term employees, but it protects the company from an unmanageable liability. I mean, think about it. If they had to pay seniority premiums based on executive salaries, a single death could bankrupt a medium-sized company.
Okay, so the cap is a safety valve for the employer, but the waiver of the 15-year rule is a safety net for the family.
Exactly. It ensures some level of compensation for tenure, no matter how short.
So we've got the finiquito and the seniority premium. Those happen in every single case. But now we arrive at the fork in the road.
Right.
The cause of death matters. Because looking at the data here, the difference between dying of natural causes versus a work-related accident is, well, it's a difference between a settlement and a fortune.
It really is a whole different ballgame. We're moving from benefits to indemnity. If the death is classified as a riesgo de trabajo, a work risk, the financial landscape shifts tectonically.
And define work risk in this context. Is it just like falling into a machine at the factory, or is it broader?
It is much broader. Obviously, it covers an accident at the workplace. But it also covers an accident in transit on the direct route from home to work, or vice versa.
Okay.
Or it could be an occupational illness, something caused by long-term exposure to work conditions.
So if the death falls into that category, what are the numbers?
First, there is immediate cash for burial. The law mandates the employer pays 2 months, specifically 60 days, of the general minimum wage for funeral expenses.
Which is helpful, getting cash in hand for the funeral home. But then comes the big one.
The death indemnity. Article 502, 5,000 days of salary.
Stop there for a second. 5,000 days, I'm doing the mental math, divided by 365. That is roughly 13 or 14 years of income.
Correct. It is a massive, massive figure. The logic is that it replaces the economic support that worker would have provided for their family over the next decade and a half.
So if a small business owner has a delivery driver who gets into a fatal accident on the route, that owner is liable for 14 years of salary. I mean, that sounds like a business-ending event.
It absolutely would be if the employer had to pay it out of pocket. But this leads us to the real aha moment of this whole deep dive. The shield.
The IMSS, the Mexican Social Security Institute.
Exactly. We have to look at Article 53 of the Social Security Law. This acts as what's called a subrogation mechanism.
Subrogation meaning the IMSS steps in and pays the bill.
Precisely. If, and this is a massive if the employer has done everything right, if the worker was registered with IMSS from day one, if the salary was reported correctly, if the premiums were paid up to date, the Article 53 shield activates. The employer is relieved of the obligation to pay those 5,000 days directly.
Yeah. So the liability transfers to the state.
Yes. The IMSS takes over. They convert that 5,000-day indemnity into a pension scheme for the widow and orphans. The employer's direct financial hit regarding the indemnity is zero.
But what if I cheated? What if I reported that my driver makes minimum wage when he actually makes 3 times that just to save on taxes?
Then you have pierced your own shield. The IMSS creates what's called a capital constitutivo. They will calculate what the pension should have been based on the real salary, see that you underpaid, and they might just wash their hands of the difference.
Wow.
Or worse, what if the worker wasn't registered at all?
Then the employer is writing that check for 5,000 days, personally.
Personally and immediately. It's the ultimate incentive for compliance. You aren't just paying taxes, you're buying an insurance policy against catastrophe.
That is a powerful way to frame it. Article 53 isn't just a rule, it's the employer's lifeline.
Absolutely.
So we know the amounts, we know the conditions. Now we get to the messy part, the human part. Who actually gets the cash? Because families are complicated.
They are. And the law anticipates this.
In the movies, this is where the long-lost cousin shows up, or the secret girlfriend. Does the law have a filter for this?
A very strict one. Article 501 of the LFT establishes a hierarchy. It's an order of preference, and you can't just jump the line.
Who is at the top? Who gets first dibs?
Tier 1 is the widow or widower. But notice I said widower too. The law is gender neutral here, but it's conditional.
What's the condition?
Economic dependence. Or, in incapacity of 50% or more, the law asks, did this person rely on the worker's income to survive? And included in this top tier are the children.
All children. Even the 25-year-old living in the basement.
No. Generally, those under 18. If they are over 18, they only qualify if they have a disability that prevents them from supporting themselves. So Tier 1 is spouse and minor or disabled kids.
Okay, so they're the VIPs. What if they don't exist? What if the worker was single and childless?
Then we descend to Tier 2, the ascendants, the parents.
But again, is it automatic? Just, my son died, pay me.
No. That condition of economic dependence applies here too. If the worker was living with their parents and paying the bills, the parents qualify. If the parents are wealthy and independent, technically they might not qualify under a strict reading of the law.
I see.
Though in practice, if no one else claims, they're often recognized just to prevent the money from being lost.
Now, Tier 3 is interesting because it reflects modern relationships. This is where we talk about the concubine.
The concubina or concubinaria.
Now, for our listeners who might not be familiar with Mexican law, this isn't just a girlfriend or boyfriend, right? Concubinado is a specific legal status.
Correct. You can't just date for a month and claim this. Generally, the requirement is you must have lived together for 5 years preceding the death in a relationship like spouses. Or, and this is the shortcut, you have had a child together.
So having a child accelerates the status.
It does. But there is a massive condition. Both parties must have been free of legal impediments to marry during that time.
Meaning neither of them was still legally married to someone else?
Exactly. This is a common point of litigation. If the worker never divorced their first wife, but lived with a new partner for 20 years, that legal wife on the marriage certificate might still have the superior claim over the partner, despite the 20 years of cohabitation.
Wow, that is a legal minefield.
It is. That's where the fights happen.
And if the list is empty, no spouse, no kids, no parents, no partner.
Then the house wins. The IMSS itself claims the funds. The money never reverts to the employer.
Okay, let's pivot to the final piece of the puzzle, the how-to. We've got a grieving family. They know they're owed money. Do they have to hire a lawyer and spend 2 years in probate court? Because in Mexico, a probate trial, a juicio sucesorio, is notorious for being slow.
This is the good news. Article 115 gives us a shortcut. It explicitly states that beneficiaries can claim these specific labor benefits, the wages, the vacation, the premium, without the need for a civil probate trial.
So it bypasses the will, bypasses the civil court.
It bypasses the civil probate route entirely. But, and this is the nuance that trips people up, it does not mean you just walk into HR and demand cash.
Right, you can't just show up with a death certificate and say, trust me, I'm the wife. The employer would be crazy to just hand over cash based on that.
Exactly. The source document highlights that under the new labor justice system, you must initiate a specific procedure, the designation of beneficiaries.
And where does this happen if not in civil court?
In the labor tribunals.
So you still have to go to court?
You do, but it's a streamlined, specialized lane. Think of it as an administrative judicial check. The judge's job isn't to divide up the house and the car and the jewelry. It's strictly to say, okay, based on the evidence, person A and person B are the legal beneficiaries for these specific labor rights.
Why is this step non-negotiable? Why can't the employer just pay the widow if they know her?
It's all about protection. Imagine you are the employer. You pay the woman who shows up on Monday. On Wednesday, a different woman shows up with a marriage certificate.
Uh-oh.
If you didn't get that judicial designation, you might have to pay twice.
Quien paga mal paga dos veces.
He who pays wrong pays twice.
Exactly. The designation of beneficiaries is the receipt that protects the payer. So while Article 115 removes the civil probate nightmare, you still need this labor tribunal stamp of approval to unlock the funds safely.
It's a fast lane, but you still need a ticket to ride.
That's the perfect analogy. This has been a lot to process, but I think we've distilled it down pretty well. If we look at the big picture, what are the main takeaways for someone listening to this?
I'd boil it down to 4 points. Number 1, the finiquito. The family is owed everything earned up to the moment of death salary, prorated Christmas bonus, and vacation with that 25% premium. Don't do the math wrong.
Don't leave money on the table. And number 2,
The seniority surprise. Death triggers the seniority premium immediately. The 15-year rule is dead. But remember the cap. Double the minimum wage. Don't expect a CEO-level payout on that specific line item.
number 3.
The cause matters. Know the difference between natural death and work risk. That difference is 5,000 days of salary. And for the employer, the IMSS is your shield. If you are compliant, the state pays that massive sum. If you aren't, you are on your own.
And finally, the procedure.
Right, you don't need probate, but you do need the labor tribunal to officially designate you as the beneficiary. It's the key that turns the lock.
It's fascinating because we often complain about bureaucracy. We say cut the red tape. But in this case, that tribunal procedure, it feels like protective red tape.
That is a provocative thought. We want simplification like Article 115 bypassing probate, but we find that total simplification is dangerous. Without that formal validation from the tribunal, the system becomes too risky for the people holding the checkbook. The bureaucracy is actually the mechanism that guarantees the money goes to the right person and that the person paying it doesn't get burned.
It's the price of certainty in an uncertain time.
Couldn't have said it better.
Well, this deep dive was heavy, but necessary. Whether you are an employer checking your compliance or a worker checking your beneficiary list, take a look at your paperwork today. It's boring administrative work until the moment it becomes the most important thing in the world.
Absolutely. Knowledge is the only real protection we have in these situations.
Thanks for listening. We'll see you on the next deep dive.